I already have a video that generally describes transportation of illegal aliens, which is a violation of 8 USC 1324, and I will link that video above. Today I'll be focusing on a particular federal guideline that a lot of times affect how much time a person who's convicted under 1324 serves in custody. In this video, I'll be focusing on one aspect of the federal guidelines as it pertains to 8 USC 1324, transportation of illegal aliens. Something to remember that in this video, I'm focusing on the sentencing stages of the proceeding, meaning that the person has pled guilty or has been found guilty through trial and convicted of transporting illegal aliens. Specifically, I'll be focusing on substantial risk of injury or death while transporting the aliens, which significantly increases the amount of exposure or time that the person will likely serve in prison. It's important for your attorney to always make good arguments and fight against any increases in the federal guidelines. After all, before sentencing, every federal judge will first calculate the guidelines or the federal guideline range that the person is exposed to. The range will go in months. Now, it's important to minimize that because although the guidelines are no longer mandatory but advisory, judges look at those guidelines first, and so that really drives the sentence. Before I'm going to talk about the substantial risk, I want to generally describe how the federal guidelines work. Every year, the Federal Sentencing Commission publishes the guideline manual to assist federal judges in sentencing individuals that are similarly situated and committed similar crimes to roughly about the same amount of time in the federal prison. Now, at the end of this book, you will find the sentencing table. In this table, there's ranges in months. Some of them go 0 to 6, some of them go all the way to life. The combination of your criminal history on top, there's 6 criminal history categories, and on the left side you have what's called offense levels. The combination of the seriousness of this offense and your prior criminal history will drive how much time you're looking at in the federal prison. Now, there could be a fight in your case over which criminal history category you fit in, because after all, it makes a big difference. And prosecutors, probation officers, and defense attorneys often fight over which priors should count into your criminal history category. Now, today I'm not focusing on that. I'll be talking about offense levels. Under 1324, transportation of illegal aliens, the base offense level is 12, which is guideline range of 10 to 16 months, meaning 10 to 16 months in the federal prison for transporting illegal aliens. Now, this is of course without accepting your responsibility points, without fast track points. This is your base offense level, meaning that's where we start. If the probation officer or the prosecution is recommending an increase for creating substantial risk of death or bodily injury to an alien, that guideline range will jump from level 12 all the way to level 18. Level 18 gives you a guideline range of 27 to 33 months. So as you can tell, we almost tripled the low end of the guidelines and doubled the high end of the guidelines. So it's a significant increase in the exposure. So it's important for your attorney to obviously fight that increase and provide the judge some explanation why the substantial risk increase should not apply to your guideline range. And so now I'll explain what it means to create substantial risk of death and bodily injury under the federal guidelines. You will find an increase for creating a risk of injury under section 2L 1.1 B6 of the federal guidelines. Now, courts have generally avoided a bright line rule when it comes to creating substantial risk. Instead, it's a fact-specific inquiry about what actually happened in your case and why that increase should or shouldn't apply. The Sentencing Commission provided some examples in the notes under the federal guidelines where they believed this increase should apply. And in the notes, it says that transporting individuals in a trunk or engine compartment of the vehicle creates substantial risk of death or bodily injury, or transporting substantially more aliens in your vehicle than the capacity of your vehicle, or harboring aliens in a crowded area, or guiding these individuals through dangerous geographic areas without adequate food, clothing, water, and protection from the elements. But of course, other than these notes, there's tons of other examples where somebody might say that there was a risk of death and others would argue that it was perfectly safe. So it's important for your attorney to look at cases and try to identify if this increase should apply. Now, at the end of the day, the court will also look at if you created the risk or this risk has to be at least foreseeable to the defendant. And so often enough in our cases, we fight over whether the risk was foreseeable to my client. And recently I had just that case where an individual picked up several people from the side of the road, but the probation officer believed that he should be responsible for the risk that those people put themselves into when they were swimming across the canal before getting into my client's vehicle to be transported further. My argument was that that area and that risk was not foreseeable to my client because after all, he didn't know when and where and how they got to the side of the highway. Now, in that case, the judge agreed with me. But it's important to always look at other cases and see how other judges and other districts ruled in order to make sure that the judge understands your position and doesn't increase your guideline range. If you enjoyed this video and if it was helpful to you, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.